You'd have a tough time finding a more high-profile legal case than what we've seen this week with former President Donald Trump. Attorney Greg Isaacs is here to talk about this. Thank you for joining us.
Lori, it's good to be here.
We're going to lay it all out here. Yesterday, as you know, federal agents raided former President Trump's Mar-A-Lago home. Specifics on that are hard to come by at this point. So instead, let's talk about search warrants. Greg, what does it take for law enforcement to get one, first of all?
Wow, Lori, each of us are protected by the Fourth Amendment, and that prohibits government without probable cause for searching your person or your property. And to get a search warrant under Rule 41 of the Federal Rules of Criminal Procedure, it's not an easy task. What you have to do is have somebody swear via an affidavit or in person, raise your hand, to a detached federal magistrate or judge, swear that there is probable cause. Now, much lower standard than beyond a reasonable doubt in a criminal case, that a criminal offense has occurred or that there is contraband that is illegal and that they believe it is being stored at that location.
So in other words, you need some kind of evidence.
You do, and the judge listens, and you have to describe with particularity the specific location that's going to be searched, and you just can't say a complex, a compound, a house, where you want to search and what you expect to find.
Interesting, because we're talking about a lot of property.
Right, and the judge often will not execute a search warrant. So then, if the judge approves the warrant, the officer that's in charge of it has to go execute the warrant. He has to be there. While there is an inventory taken, which is a very serious procedure, and then the inventory of items seized must be listed and must be returned to the court.
Let's talk about what can go wrong in search warrants.
Well, two things can go very wrong. If you're law enforcement, you're tempted to look outside the confines of the four corners of that search warrant, and that's a no-no. Anytime you do, the evidence is inadmissible. Wow. Conversely, if you're the citizen and someone goes in to search for X and Y is in plain view, and that's the operative word of law enforcement, then it's fair game. So if there's something else that they see that's in plain view, it can be seized by law enforcement.
It's got to be right under their noses. Really quickly, before we let you go, former President Trump did send out a statement today saying he refused to answer questions under oath in a New York civil trial. Explain what it means to take the fifth.
When you take fifth, that is a very broad legal concept that just means you are not constitutionally compelled to incriminate yourself. Now, that doesn't mean you committed a crime. That doesn't mean that that question directly is related to a specific criminal conduct, but it means that you think directly or indirectly you could have some inculpating issue if you gave a response. So,
all right.
And lawyers always say more often than not, take the fifth. But very interesting, but Lori, just because there's a search warrant does not mean there's going to be criminal charges.
All right, we'll be watching. Greg, thank you. And if you have a legal question for Greg, you can reach out to him by emailing askisaacs@wate.com. And remember, we talk with Greg every Wednesday at 5:30 right here on WATE 6 on your side.